We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Today, we want to first thank you for watching Law School Made Easy and also to urge you to continue watching, subscribing, sharing, and liking our videos. Also, we want to urge you to watch the adverts. You have noticed that on our videos, the adverts now, please, they are just 30 seconds. Endeavor to watch and then you can continue with your video. That is one way that you'll be supporting this channel, appreciating this channel for the good work that you say in the comment we are doing. Today, we want to straight go into contract law, and this is contract 2. And particularly, I want to look at the first topic, that is misrepresentation. In our previous discussion, or in first semester for law students who are in first year, what you do is to formation of a contract. You form a contract by way of this studying the offer, acceptance, elements of a contract, consideration, intentions, technical bound, capacity, and all that. So in first semester, you were forming a contract. Now in second semester, we are discussing the vitiating factors, things that vitiate a contract, things that can end the contract suddenly, things that can stop the contract even when it had started. What are some of those things which are called the vitiating factors? So we are going to discuss the various vitiating factors, and they include misrepresentation, mistake, duress, undue influence, and discharge, and very many others. So today in this particular video, we want to focus particularly on misrepresentation. We need to discuss what is misrepresentation and what are some of the guiding factors or elements that govern this all misrepresentation, and then we shall look at the types of misrepresentation, which namely include the fraudulent misrepresentation, the negligent misrepresentation, and the innocent misrepresentation, which will now take us to the remedies available. The remedies available for misrepresentation, and that would be the end of this video. So to start with is misrepresentation. The way you hear the word misrepresentation, this has been defined in the case of Fred Nwagaba versus Ade Musa Nakanguma. Now, in this case, it was said that misrepresentation is a false statement of fact which is aimed at inducing the other party to enter a contract. That when we talk about misrepresentation, we are discussing a false statement of fact, that the statement is false and it induces, it somehow makes the other person to believe in it, and then that person will now be able to enter this contract. Is entering a contract basing on the false statement of fact which has been issued or said by the representer. We are going to come across the word representer and representee. Representer is the person who is making that statement, and then representee is that person who has received the statement, who has based on that statement to enter into a contract. So that is what we refer to as representee and representer. Now, in discussing misrepresentation, we must first be able to find out, did the other person accept the contract depending on the false statement of fact which is said? That is the first thing you need to prove. Number two, there are two statements. One is the statement of fact that we are saying is a false statement of fact, and then the statement, the opinion, that in this case we give opinion, but what amounts to misrepresentation in terms of statement of fact and statement of opinion. Now, statement of opinion cannot amount to misrepresentation. In any case, that is why if you hear all the lawyers and other people when communicating their day-to-day English, if you use the word opinion, that's why they say everybody is entitled to their opinion, simply because we cannot prove the actualness of that statement you have said. It is a statement of opinion, because we cannot ascertain that. What do you want to prove? What do you mean? It is your opinion. You are just thinking about it. So a statement of opinion cannot amount to misrepresentation. We have a case here. We have a case of Bissett versus Wilkinson. Now, Wilkinson was the owner of the ranch, a farm, and then these people wanted to buy the farm. Asked him, what do you think can this farm accommodate? So he said, in my opinion, I think this farm can accommodate 2,000 sheep. Now, in any case, when they bought the farm, they actually found out that the farm cannot accommodate the 200 sheep he had talked about. So court held that it was a mere statement of opinion, because even him, Wilkinson, had never put the 2,000 sheep on that farm. So that one now becomes a statement of opinion. It can never amount to misrepresentation. Then the other element governing misrepresentation is the change of circumstance. That where there is change of circumstance, this would be silence does not amount to misrepresentation. We are saying that silence cannot in any way amount to misrepresentation. But we are saying that if you read section 14, clause 2 of the Copyright Act says that silence in itself cannot amount to misrepresentation. But where it is the duty of the one keeping quiet to speak, it can amount to misrepresentation. And then, if silence in itself is equivalent to speech, then that way silence can amount to misrepresentation. I want to repeat this. Section 14, clause 2 of the Contract Act states that silence in itself cannot amount to misrepresentation. But if it is the duty of the one keeping quiet to speak, then it can amount to misrepresentation. And if silence itself in itself is equivalent to speech, then that way it will amount to misrepresentation. Now, let's look at change of circumstance. We have a case, I think, of With versus O'Flanagan. Yes, With versus O'Flanagan. Now, in this case, a doctor was selling his medical practice, and he told these people, the With, that look here, this can make amount of money, you get a lot of profits, ABCD. So basing on the statements said by the doctor, but later the amount decreased because he fell sick and the amount of money decreased. Now, these people bought the medical practice thinking that they are going to make a lot of profit, but along the way things had changed, and O'Flanagan did not communicate to them the change of circumstance. So it was held that it is the duty that where there is change of circumstance, it is the duty of the representative to now communicate to to the representee that look here, things have changed. Remember the time we talked, but now things are not the same. In the event that you don't communicate, you keep quiet, then silence will amount to misrepresentation, because we are saying that where it is the duty of somebody keeping quiet to speak and they don't speak, then silence will amount to misrepresentation. Change of circumstance is the first exception. To silence does not amount to representation. Then we can go to where things are said half truth. That yes, it is a duty for you to keep quiet in some moments, but where you decide to speak, you must speak everything. So this thing of I only told them less, I left the other, then that way silence will amount to misrepresentation. That when it is the duty for you to speak, kind of speak everything. You have the chance, where the transaction, tell us everything. Don't speak half truth and then you leave the other. So we have a case there. I think it is Demok versus Haaland. Now, Demok versus Haaland in that case,